The
President, please be seated. The court is now in session. Yesterday, we already heard observations concerning the preliminary objections on the grave breaches of the Geneva Convention. And we left off with the response from the prosecutor. Next, we would like to proceed to the civil party, the lead co-lawyers for the civil party to make their oral submission.
Some group look at Krampathian.
Counsel Pick Ang, Mr. President, Your Honors. The President interrupts. Mr. Nuon Chea, you may now proceed. Nuon Chea, I am Nuon Chea. Mr. President, Your Honors, my fellow Cambodian citizens, since today's hearing is still about Ieng Sari's case, I am Nuon Chea, and I would like to ask that I am excused. I would like to return to the detention facility. I only return to this courtroom and to cooperate with the court actively when my case is on the agenda. The President, having heard your request concerning your reason for being accused, and according to Rule 81(4), such request is relevant. You are now allowed to be accused from today's hearing. The security personnel are now instructed to bring the accused Nuon Chea back to the detention facility. We shall now proceed to the lead co-lawyer.
Your Honours, sorry for the interruption. Yesterday, Your Honours announced that the hearing may continue until Friday. Until now, I don't know when I will be flying back to Europe, and it may very well be tomorrow night. And I would like to be sure that I'm present during the objections to the witness lists. So I would ask Your Honours to schedule the hearing in such a way that tomorrow we'll deal with the number 8 on the agenda, the objection to the witness lists. Thank you.
The President The chamber, thank you for your observation. Yesterday, the chamber only made an estimation having looked at the items of the agenda that have already been conducted during the last few days, and we have observed that we may lag behind the schedule. That's why we have planned that Friday may be continued, may be considered as another day for the hearing. And because we, of course, believe that tomorrow or on Friday, all lawyers will be present. However, we are seized with your request, and we will take the matter into consideration, and the chamber will do its best to make sure that the items of agenda are well covered as scheduled, and that if it can be finished by Thursday. Council Pick on. Good morning again, Mr. President, Your Honors. With regard to the topic for discussion as yesterday, today the civil party lawyers would seek the President's permission to let the three civil party lawyers to respond to the observation. First, Counsel Som Sokung will be giving his oral submission, followed by Lima Nguyen, and finally Mr. Pascal Auboin. The President, the civil party lawyers are of course allowed to make their oral submissions, and please be informed that the three lawyers have 30 minutes allocated time for such submissions. Counsel Sokung. Good morning, Mr. President, Your Honors. I am Som Sokung, representing civil parties in case 002 before the ECCC. I will be responding with regard to the observation by the Defense Counsel of Ieng Sary regarding the grave breaches of Geneva Convention. I, of course, will speak firstly on the proposed statute construction concerning Article 6 of the ECCC, Article 109 of the Cambodian Code. My international colleague, Ms. Lima Nguyen, and Mr. Pascal Auboin will then speak about the just cautions nature of grave breaches of the Geneva Conventions. Yesterday, having studied further the case file and having observed the response by the co-prosecutor to the defense counsel, I am Som Sokung. Here, I would like to really strongly support the arguments by the prosecutors. And at the same time, I would like to add a few more points for your Honor's consideration. Before the ECCC law was established, the royal governments of Cambodia and the United Nations had several rounds of discussions and negotiations. And the national laws, altogether with international laws, have been in consideration. Article 1 and Article 2 of the law states the purpose and the jurisdiction of the court. And the court itself has jurisdiction over Cambodian law and international law. Articles 3 and Article 5 really state the matters with relation to the domestic laws. Article 6 of the ECCC law provides that the ECCC has the power to bring to trial all suspects who committed or ordered the commission of grave breaches of the Geneva Conventions of the 12th of August 1949. The contended question is whether the statute of limitations under Article 109 of the 1956 Cambodian Penal Code applies to grave breaches within the court's jurisdiction. The defense argues about this its application are irrelevant, particularly when examined in light of the very function and purpose of the ECCC. The drafters of the rule already had in mind when it comes to having these articles included in the law. The defense raised the specific provisions in Articles 4 and 5 of the Establishment Law, which provide that no statute of limitations applies for genocide and crimes against humanity. They contend that the statute of limitations in Article 109 of the Cambodian Penal Code is applicable to all crimes committed in Cambodia at the relevant time. They then conclude that silence in Article 6 in respect of the statute of limitations means that the drafters intended that a statute of limitations should apply to grave breaches. To respond to the defense team, we believe that the defense counsel has misunderstood this article. The defense argued that if followed would lead to an absurd outcome. If domestic statute of limitations applies to grave breaches, none of the crimes could actually be prosecuted before the court, as the statute of limitations would have expired in 1989. This is almost 14 years before Article 6 was ever drafted. The code clearly applies only to persons who committed a felony within the meaning of the 1956 Penal Code. And cannot be constructed as a felony as understood in Article 109. It follows then that the statute of limitations referred in the 1956 Penal Code cannot apply to grave breaches. Clearly, the legislators would not have included grave breaches in the normative jurisdiction of the ECCC, knowing that the enumerated crimes could never be prosecuted. It was clear at the time that the ECCC law was drafted that grave breaches under the Geneva Conventions was understood to have already attained the status of just cogence, norm of international law. Unlike crimes against humanity and genocide, the Geneva Convention had an established status internationally with 133 state parties in 1975. and did not require special mention of non-applicability of a statute of limitations. Any such mention would have been both redundant and completely unnecessary. Cambodia's National Assembly, in discussing during the drafting of the ECCC law, also decided to extend the statute of limitations for crimes within Article 3, but did not discuss such a limitation for the international crimes under Articles 4, 5, or 6. This indicates clearly that the statute of limitation does not apply to Article 6. Further, the report by the group of experts supported the fact that the legislators deliberately considered the potential implications of the statute of limitations for the only offenses for which a statute of limitations was intended to affect national crimes under Article 3. The trial chamber in case 001 found the accused Kang Kek Eo alias Doj guilty of violations of grave breaches as defined in Article 6 and noted that each grave breaches provision enumerates particular offenses for which universal mandatory criminal jurisdiction exists among contracting states. In case 001, the statute of limitations received extensive judicial consideration, but only in relation to Article 3. And this leads to a clear conclusion that the drafters and subsequently the trial chamber judges never contemplated the application of a statute of limitations for Article 6. This leads to a very clear conclusion that the trial chamber judges, of course, never contemplated that application of the statute of limitations for Article 6. And as indicated earlier, my co-colleagues will be also making oral submission concerning the just cautions and also the grave breaches of the Geneva Convention. I am very grateful, Your Honors, and I would like to now hand the floor to my colleague Lima Nguyen.
Good morning, Mr. President, Your Honours and colleagues. If it pleases the Court, my name is Lima Nguyen, appearing for the civil parties. Yesterday, our colleagues from the prosecution made comprehensive submissions on the international status, the status of international law at the ECCC and the customary international law status of grave breaches. Today, the civil parties will emphasise the jus cogens status of grave breaches in responding to the question from the trial chamber as to whether a statute of limitations was envisaged and permissible in customary international law within the period 1975 to 1979. Jus cogens norms are understood as mandatory or peremptory norms of general international law accepted and recognised by the international community as a norm from which no derogation is permitted. These norms create obligations erga omnes, or incontrovertible obligations which apply to all states. Much has already been said about Article 53 of the 1969 Vienna Convention on the Law of Treaties. And prior to the formal recognition of jus cogens norms in the Vienna Convention, there had been significant debate and discussion about the concept. Importantly, Cambodia was amongst the first states to sign the Vienna Convention at the drafting conference, at which there was full agreement as to the existence of such norms. Our learned colleagues from the prosecution yesterday addressed the criteria for a norm to attain the status of customary international law. The civil parties will address the criteria today for the elevation of a norm to jus cogens status in international criminal law. These requirements are firstly, that a large number of states ratify a treaty. Secondly, that the language in the preamble or treaty provisions indicate the higher status of the relevant crimes in international law. Thirdly, if there are ad hoc international investigations and prosecutions of the perpetrators of such crimes. And fourthly, where there is evidence of opinio juris demonstrating that the norm is general customary law. The Geneva Convention's regime is one of the most time-honoured, well-established and universally accepted codifications of international law. It has foundations dating back to the Lieber Code of 1863, which dictated how soldiers should conduct themselves during the American Civil War. Grave breaches of the Geneva Conventions are jus cogens norms of international law. This means that these particular war crimes are not subject to a statutory limitation, and particularly not one imposed by a domestic penal code that does not even refer to such crimes. The civil parties assert that grave breaches of the Geneva Conventions had attained jus cogens status prior to the 17th of April 1975, when the accused persons undertook their roles as leaders of the Democratic Kampuchea. The number of state parties to the convention at the relevant time may speak for itself. As at the 17th of April 1975, 133 parties out of 138 UN member states, and including all the permanent members of the UN Security Council, had become parties to the conventions. This number constitutes 96% of all UN member states at the time. Importantly, Cambodia ratified and acceded to all 4 Geneva Conventions on the 8th of December 1958, and more importantly, without recording a single reservation or raising any issue about statute of limitations. To properly place the acceptance of the norms contained in the Geneva Conventions in relation to other international norms, it's worth it to highlight that no other international human rights treaty, including the Genocide Convention, the International Covenant on Civil and Political Rights, and the International Covenant on the Economic, Social and Cultural Rights, came close to having the same number of state parties in 1975. This is also true as at today. Prior to the 17th of April 1975, the international community clearly understood that grave breaches of the Geneva Conventions had elevated status in international law. And the clearest example of this is the preamble to the 1968 UN Convention on the non-applicability of statutory limitations to war crimes and crimes against humanity, stating that these crimes are amongst the gravest crimes in international law. Now, we note yesterday that the defence had raised objections, the objections made by Honduras to the statute of limitations provisions during the drafting of that convention. But to rebut this point, the civil parties wish to make clear that the fact that a limited number of states dissented against a norm of international law does not bar that norm from becoming a customary international law. Rather, a state's persistent objection to such a norm may allow that state to assert that the norm does not apply to the state concerned. War crimes prosecutions constitute a central feature of both the Nuremberg and Tokyo tribunals undertaken by the international community in the wake of World War II. From 1945 to 1948, 3 separate tribunals, the International Military Tribunal, the US Nuremberg Military Tribunal, and the International Tribunal for the Far East, had tried suspected criminals for these crimes, and this has later served as the foundation for the grave breaches regime. The lack of prosecutions on war crimes and grave breaches between the period 1970 to 1990, as mentioned by our colleagues, the prosecution yesterday, were, the civil parties assert, a consequence of the geopolitics of the period. However, The first tribunals to emerge in the 1990s took for granted that both the obligation to prosecute and the crime of grave breaches in themselves were already well established as jus cogens norms. The ad hoc international courts, including the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, and the Special Court of Sierra Leone, have jurisdiction over and have prosecuted cases of grave breaches. The ICTY case of Prosecutor and Kupreskic found that most norms of international humanitarian law, and in particular those prohibiting war crimes, crimes against humanity, and genocide, are also peremptory norms of international law or jus cogens, that is, norms of a non-derogable and overriding character. Article 53 of the Vienna Convention sets out that a jus cogen norm can only be invalidated through a subsequent norm of the same standing. If there is doubt as to the interpretation of a jus cogen norm, other subsidiary norms, including customary law and positive law, and whether or not domestic or international law, must be interpreted in a manner conforming to the requirements of the jus cogen norm. Consequently, it is our submission that the statute of limitations provision under the 1956 Cambodian Code, which undermines and contradicts the jus cogens nature of grave breaches and the corresponding duty to prosecute these crimes, cannot apply to grave breaches. The prosecution have yesterday already addressed the absolute duty to prosecute grave breaches, and we will not repeat those submissions. In summary, statutory limitations in relation to grave breaches of the Geneva Conventions were never envisaged within customary international law, and in particular in the period 1975 to 1979. Nor were they permissible under customary international law at the relevant time. And this is precisely because the crimes of grave breaches had, by the 17th of April 1975, not only become customary international law, they had by then reached the status of jus cogens under international law. And I now give the floor to my colleague, Mr. Pascal Auboin, to further this point.
Mr. President, Your Honours, dear colleagues, I will simply add a few observations saying that grave breaches are not subject to statutes of limitations. Jus cogens has a nullifying effect on the statute of limitations contained in the Cambodian Penal Code of 1956. In this case, a jus cogens norm requiring the prosecution of grave breaches of the Geneva Conventions cannot be overridden by an inferior rule, namely a statute of limitation provision under domestic laws. The Geneva Conventions are silent on the question of a statute of limitations for grave breaches. Reservations made by states parties to the Geneva Conventions do not refer to statutes of limitation or the non-retroactivity of the provisions of the treaty. Moreover, a number of domestic laws explicitly prohibit the application of a statute of limitations for war crimes. The Vienna Convention provides that a national procedural norm conflicting with a jus cogens norm cannot prevail over the jus cogens norm. In this case, the statute of limitation provision under the 1956 Cambodian Code cannot impede on the prosecution of grave breaches. The Convention on the non-applicability of statutory limitations to war crimes and crimes against humanity places an absolute ban on the application of statutes of limitations to war crimes and crimes against humanity. As the Convention entered into force in 1970, the normative principle that no statutes of limitation should apply to grave breaches existed during the period of the temporal jurisdiction of the ECCC. By April 1975, the obligation to prosecute grave breaches of the Geneva Conventions had already risen to the level of a jus cogens norm under international law. No norm can frustrate or invalidate the erga omnes obligation arising from a jus cogens norm. The International Criminal Tribunal for former Yugoslavia case of Furunzija is one example where an international court decided on whether a domestic level law can override the jus cogens prohibition on torture. In this case, the ICTY held in that domestic law on statute of limitations cannot apply. The defense preliminary objections are based on an erroneous premise that a statute of limitations may apply to grave breaches of the 1949 Geneva Conventions. The defense arguments should be dismissed on the basis that the obligation to prosecute grave breaches is a jus cogens norm from which there can be no derogation. A statute of limitation would amount to such a derogation which is prohibited under international law. Thank you very much.
The President, thank you, councils, for the civil parties, for your presentation. I would like now to give the floor to the Israeli defense team to take the floor for 15 minutes to reply if they wish to do so.
Good morning, Mr. President. Good morning, Your Honors, and good morning to everyone in and around the courtroom. I just have a few brief remarks. The presentations by the prosecution as well as by the civil parties has been an excellent one and somewhat persuasive. We do depart on various grounds, however, and we do maintain that while their argument may appear to be persuasive, it lacks traction. We do not agree that by 1975 to 79 that grave breaches had reached or had been elevated to jus cogens. So we have that fundamental disagreement. Yesterday, we presented concrete evidence showing that there has been an ongoing debate concerning the applicability of statute of limitations. Now, there was a rhetorical question posed yesterday by the prosecution, how could this be? And to some extent, that rhetorical question also is being echoed today by the civil parties. Well, when it comes to the grave breaches, war crimes, it could be that there may be an exception, if you will, that parties, the states, are reluctant to simply go along on this particular area of the evolving law of international criminal law because it is states that go to war. And perhaps because of their narrow interest, their interest in guarding their national sovereignty, it is for those reasons why we presented to you the various discussions and various positions taken by the various states. And so when you look at the discussions and you look at the number of states that have signed on to the non-applicability of the statute of limitations concerning war crimes. One cannot come to any other conclusion that by the period of 1975 to 1979, it had not reached the level of customary international law, let alone be elevated to use cogents and therefore giving rise to the arguments that we heard today by the civil parties. So we maintain our position that from 1975 to 1979, the statute of limitations applied to the grave breaches of the Geneva Conventions. We have argued this point extensively in our pleadings. You've heard our initial argument yesterday, and you've heard very eloquent arguments from the other side. And I'm sure you'll reach the right decision based on the written and oral submissions. Thank you, Your Honors.
អរគុណលោកមេធាវី
The President, thank you, Counsel. We will now move to the next agenda. That is the oral argument on statutory limitations in relation to offences contained in the 1956 Cambodian Criminal Code. The Chamber will now hear oral argument on the final preliminary objection for consideration during this initial hearing concerning statutory limitations in relation to offences contained in the 1956 Cambodian Criminal Code. This preliminary objection has been raised by all defense teams. The defense has been allocated a total of 2 hours for the presentation of this preliminary objection, as previously indicated. Unless agreement between the various teams has been reached to the contrary, the Chamber will allocate 30 minutes to each defense team. The co-prosecutors and civil party lead co-lawyers shall then each have 1 hour in response, and the defense teams have a combined total of 30 minutes in reply. The Chamber has not stipulated any particular issue to be considered by the parties in relation to this preliminary objection. It has, however, clarified that the Ieng Sary defense may address orally the points it has raised in supplementary submission E94 within the time allocated to it if it so chooses. The Chamber would like now to give the floor to the 4 defense teams to make their presentations on the arguments in relation to the national crimes as stated in the 1956 Cambodian Criminal Code. Mr. Kanavas, you may proceed.
Good morning, Mr. President and Your Honors again. I am told that the Nuon Chea defense team will not be making presentations today, so we will be going first. And I turn the floor to my colleague, Mr. Angodom.
Angodom. Good morning, Mr. President. Good morning, Your Honors. Today, I will make a brief presentation in relation to the applicability of national crimes and arguments, and my colleague, Mr. Michael Canavas, will follow up with more detailed explanation of our argument. And we will address any questions your honors may have. The 1956 Penal Code has been recognized as the penal code which was in effect during the time period over which the ECCC has temporal jurisdiction. This penal code contains provisions criminalizing homicide, torture, and religious persecution. It also contains a statute of limitations which prohibits prosecution of these crimes after 10 years have passed since their commission. Your honors, the statute of limitations for crimes allegedly committed in 1975-1979, which is the temporal jurisdiction of this court, expired by January 1989. In 2001, the law on the establishment of the extraordinary chambers in the courts of Cambodia for the prosecution of crimes committed during the period of Democratic Cambodia was enacted. Article 3 of this law gave the ECCC jurisdiction over the 1956 Penal Code crimes of homicide, torture, and religious persecution. And extended the applicable 10-year statute of limitations by an additional 20 years. In 2004, this law was amended. Apparently, because a 20-year extension of the statute of limitations would expire before all expected cases could begin at the ECCC, the extension of the statute of limitations under Article 3 was changed from 20 to 30 years. The establishment law essentially goes back in time and makes it as if the statute of limitations never expired. This creates a problem because the principle of legality prohibits the retroactive application of law. It is also problematic because the establishment law applies only at the ECCC. This means that Mr. Ieng Sary could be charged with a crime that a similarly situated accused in any other court in Cambodia could not. This violates his right to equality before the law. Your Honors, one of the co-investigating judges apparently realized this problem. In the closing order, the co-investigating judges stated that they attempted to issue a common text on the questions of being tried twice for the same facts. The limitation period for the relevant national crimes and on the effect of the Constitutional Council decision of 12 February 2001. But they have not been able to. The co-investigating judges did not elaborate upon their respective positions on these issues. They stated that they found themselves in a procedural stalemate, which is partly due to the hybrid structure of the ECCC. The co-investigating judges chose not to employ the procedural mechanism in the rules for resolving disputes, believing that this would put into peril the entire legal process. And they decided to leave it to the trial chamber to decide what procedural action to take regarding crimes in the 1956 Penal Code. We submit that Article 3 new may not be applied because a. The co-investigating judges disagreed as to whether it is applicable, and it thus may not be applied. B. Application violates Mr. Ieng Sari's fundamental right to be treated equally before the law, and C. Application violates the principle of non-retroactivity. Your Honors, my oral argument and presentation comes to an end now, and my colleague will provide further details to your honors. Thank you, Mr. President and your honors, for your attention.
Mr. President, your honors, as I've indicated on past occasions, our written submissions are rather
The President. In order to clarify the time allocation for the 4 defense teams, as they all have a total allocated time of 2 hours, and for Ieng Sari's team, so far have made their presentation, and for Mr. Noon Chee's team, according to the counsel for Mr. Ieng Sari, said they did not wish to make their presentation or argument on this issue. And I'd like to clarify with the counsels for Mr. Noon Chee if they wish to take the floor. If not, then the chamber will reallocate the time to the other defense teams. So then they would have the appropriate allocation of time for the 3 remaining defense teams. Unless the 4 defense teams agreed to the time allocation within amongst themselves.
Your Honours, we donate our time to the Ieng Sari team. We are not going to speak on this issue. Well,
The President. Thank you, Counsel. What about the defense team for Ieng Thirret? Would you wish to make your presentation regarding its preliminary objection? Pat Bausian. Good morning, Your Honours. As the defense team for Ms. Ieng Thirret, we would not take the time to make any oral presentation as we already have made our written submission. The President. What about the defense team for Mr. Kieu Sampon? Mr. Sawsawan, you may take the floor. Sawsawan. Good morning, Mr. President, Your Honours, prosecutors, and lawyers for the victims. As well as the defense counsels for the accused. I do not want to interrupt the flow of the proceeding. As my colleagues just said, we already filed our written pleadings to the trial chamber regarding this preliminary objection. On the statutory limitation of the 1956 Penal Code. So far, based on my observations, sometimes the word used here are so technical, and sometimes it is hard for me to follow and to understand. The President, Counsel, what the Chamber would like to know is that regarding the statutory limitation of the 1956 Penal Code, and where the time allocation has already been assigned for each defense team, would you take that time to make your arguments regarding this objection or not? If you say no, the time will be allocated to Ieng Sari's defense team to use it. If you need to take the time to make your presentation, then of course you will have that time, and the rest of the time will be reallocated amongst your group and the Ieng Sari's defense. Otherwise, you are not allowed to talk on other topic. As the President said, for each of the 4 defense teams, we have 30 minutes. I do not want to take 30 minutes. I only need 20 minutes to talk on the statutory limitation of the 1956 Penal Code. The President, yes. That is all what we want. So that the rest of the time allocation can be given to Mr. Kanavas, the Ieng Sari's defense team. Mr. President interrupts. I think it is time for Mr. Kanavas to continue with his presentation, and your time will come next. Mr. Kanavas, you may now proceed.
Thank you, Mr. President. First, let me preface my remarks by saying we are grateful with the generosity extended by the trial chamber in allowing us to make these submissions. So I will not abuse that generosity by spending all of the time that has been allocated, but rather I believe I only need about 10 or 15 minutes at most. And again, thank you. I just want to address a little bit or expand a little bit on the argument concerning Article 3 and a couple of the arguments that were raised by the prosecution. With respect to Article 3, new, the national crimes may not be applied because application would violate the principle of non-retroactivity. That's our position. We maintain and we submit that the Constitutional Council, which concluded that the extension of the applicable statute of limitations of Article 3 new was constitutional, we submit that that was an error. But we also recognize that you, Your Honors, and the ECCC in general does not have the authority, the competence to decide on issues of constitutionality. However, even if you were to, even if we assume for the sake of argument, which we must, that this is constitutional, the principle of non-retroactivity of law is a fundamental principle, and Mr. Ieng Sari has a right not to have retroactive laws applied against him. That's our fundamental argument concerning this particular point. And we rest on Article 6 of the 1956 Penal Code, which forbid the retroactive applications of law. You can also find in the international conventions, such as the Universal Declaration on Human Rights and the International Covenant on Civil and political rights, that also is recognized, the non-applicability or forbidding retroactive application of laws. And again, we have covered that extensively in our brief, so I won't belabor the point. Now, the prosecution has asserted that Article 3 new may be applied without violating the principle of non-retroactivity because statute of limitations in Article 109 of the 1956 Penal Code says may have been told, and thus the original statute of limitations may have been extended before it expired. So they're resting their argument that there is this possibility that it may have been told. Well, as a matter of legal principle, we all recognize that statute of limitations, under some circumstances, may indeed be told. For instance, where there is an investigation in process. That might be one such situation. We submit for, with this particular case, we had the 1979 trial. So clearly, there was the recognition of the events, of the individual. And you could consider the trial itself as an act of prosecution, which could toll the statute of limitations. But thereafter, after 1979, we see no evidence of further investigative action. Nothing whatsoever. It could be that there simply wasn't any political will. But lack of political will is not an exception. We maintain that the judicial system in Cambodia during the periods of 1979 all the way up until 1991 was indeed functioning. And Cambodia had the capacity to investigate if it wished to investigate this matter. It simply chose not to, for whatever the reasons were. It certainly wasn't because war prevented it, because we can see from the records that the judiciary was functioning and the trials were being carried on and investigations carried on throughout Cambodia during this period. But perhaps like cases 003 and 004, there may have been a lack of political will to prosecute, which is why there was a lack of investigation or lack of a follow-up on these events. Next, the prosecution has suggested that the extension of the statute of limitations is a procedural rather than a substantive matter, and therefore the principle of non-retroactivity may not be applicable, since it only deals with procedure and not substance. And we maintain that it matters not whether it's procedural or substantive. A law extending a statute of limitations has a bearing on the prosecution and sentencing, which sets it apart from procedural laws. And even if it were procedural, Mr. Ieng Sary is entitled to just as much, he's just as much entitled to procedural justice as he is to substantive justice. We have demonstrated in our written submissions that there's evidence that states view the abolition of amendments of a statute of limitation for crimes that have already been time barred as a violation of the principle of non-retroactivity. And this can also be seen by way of analogy also when you look at the 1968 Convention on the non-applicability of statutory limitations to war crimes and crimes against humanity. I urge your honors to look at that carefully, because you see a discussion and you see the reasoning behind why states disagree on this notion that you can simply restart the clock by passing a law after the law has expired or the time to investigate and prosecute has expired. I believe this concludes my remarks, Your Honors. And again, thank you for giving us the opportunity to address this very discrete issue on this matter of law. Thank you.
អរគុណលោកមិត្តវីជាកិច្ចបន្តអង្គ
The President, thank you, Counsel. We would like now to proceed to Counsel for Khieu Samphan, Counsel Sasawan. You may now present your oral observation concerning the topic being discussed. Counsel Sasawan, good morning, Mr. President, Your Honors. The prosecution and the civil parties for the victims and the counsels for the accused and the public. I will not repeat what Counsel Kanawaz already indicated, but what I would like to stress is that my client who is behind me was the former head of state. In English, it is the head of state, and in French, chef d'État, and of course in Khmer, Pramuk Rat. I think at that time there were three important people as the state presidiums, Mr. Khieu Samphan, Ruos Nyim, and Sao Pham. My impression is that my client, who was the former of the state presidium or the head of state, he received these functions from the former king when the king resigned on April 1976. From April 1976 until the collapse of the Democratic Cambodia, there had been only one constitution, the constitution of the Khmer Rouge, the 1976 constitution. He was in his capacity as the state presidium or head of state. I would like now wish to touch upon the statutes of limitation with regard to the 1956 Penal Code of Cambodia. His function back then was not different from Mr. Jacques Goji. In the democratic country, I think that there are problems inside that states, but I do not want to really dig into that matter. I would like to come back to the statute of limitations of the 1956 Penal Code. The code states if someone commits a crime, the statute of limitation will run out after 10 years when the crime was committed, if there was no proper prosecution. But the statute of limitation here is also seen in the statute of limitation in sentencing. And for example, if a person is found to be guilty and sentenced to 10 years of imprisonment, the person escaped or was at large, then that statute of limitation will lapse after that period of time. Yesterday there was in-depth debate on this, and Mr. Ieng Sari made a request, and counsels for the civil party lawyers refer to the amnesty as obtenoy in French. And of course, I am not really acting to protect any of the accused if he or she is found guilty of war crimes, things like that. The President interrupts. Counsel Sorsawan, could you please be reminded that you are allowed to only make your oral submission with regard to the statute limitations concerning the 1956 Cambodian Penal Code, and whether such code is applicable before the ECCC with regard to 3 crimes here. This is the primary agenda for your submission. Counsel Sorsawan, mic is not activated, says the interpreter. Counsel Sorsawan, I apologize, Mr. President. I fully support the arguments made by Counsel Kanawaz for Ieng Sary. I just would wish to add a few more points, and of course I will be brief because I have to respect the time given. The statute of limitations is intended for some certain period of time, and of course it will run out after that certain period of time lapsed, and we have to really be abided. Everyone have to respect the non-retroactivity of criminal law, and for some severe crimes, for example, such principle shall be strictly applied. And I think I'm running out of time. We of course would like the society to forgive and forget. My father died, and of course I thank the civil parties for helping to really commemorate the death of people who perished, of course, during the Khmer Rouge regime. And I would like to reiterate my position that if any of the client here is found to be guilty, then they shall be prosecuted and sentenced. I am not really saving them, but I would like only the court to make sure that justice is done, and that I would like all Cambodian people to understand the truth. And thank you very much, Mr. President and Your Honors. The President, next the Chamber would like to give the floor to the prosecutor to respond, should they wish to do so. National Prosecutor. Thank you, Mr. President. Good morning, Your Honors. I will be responding to the statute of limitations with regard to Penal Code of 1956. The Office of Co-Prosecutor would request that the trial chamber set aside all the oral submissions as indicated by the defense counsel. The President's counsel for the inquiry, you may proceed. Counsel Ang Odam. Mr. President, may we request that Mr. Ieng Sary be excused and that he can observe the proceeding from the holding cell because he has experienced back pain. And I recall that yesterday in the morning, the President asked me about the reasoning behind our request for Mr. Ieng Sary to be excused and observe the proceeding at the holding cell. So I may now wish to also make sure that this request also be considered for this afternoon session.
បានស្ដាប់សំណើ
The President, the Chamber has taken note of the request by the Defense Counsel and hereby grants the permission for Ieng Sary to be excused and observe the proceeding from the holding cell due to his health condition. Mr. Ieng Sary shall still participate in the proceedings through remote participation through the AV equipment that have been installed at the holding cell where he will be staying. And he will be allowed to observe the proceeding for the whole day today without coming back to this courtroom. The security personnel are now instructed to bring Ieng Sary back to the holding cell and make sure that AV equipment is installed so that he can fully observe the proceedings from that room. The National Co-Prosecutor, you may proceed. National Co-Prosecutor. Thank you, Mr. President. President, we would like now to proceed with our oral submission, and that the statute of limitation in the 1956 Penal Code has not yet run out because we, the co-prosecutor, submit that this statute of limitation can be extended if there is reasonable ground for such extension as follow. For example, number one, no statute of limitations existed under the RPK period until the UNTAC Code was issued in 1992. To the general principle of the suspension of the statute of limitations, and the suspension of limitation was in place because the code was not functional. The suspension of statute of limitations due to the mistake due to the situation of war, and also the suspension of the statute of limitations because of the error committed by the accused. I would like now to respond to the Defense Counsel concerning the suspension of the statute of limitations with regard to Penal Code of 1956. Point 1. The law system of Cambodia. During the Democratic Cambodia, the court system was ground to a halt. According to some documents, the reason why the judicial system was dysfunctional was because the CPK treated judges, lawyers as target for extermination. Although in the constitution of the DK there is the existence of the court system, but such a court would never be functional. From 1979 to 1991, during this period of time, the judicial system was established by the People's Republic of Cambodia and was functional until 1992 and 1993. During this period of time, both civil law system and the Penal Code of 1956 were not applied. They only applied this decree law of 1980 and another decree law created in 1982. And the main offense at that time was on the offense concerning the betrayal of the revolution. Those who drafted the rule and provisions for judicial system at that time were former teachers and people who had very little training in law. And on top of that, the accused person at that time did not really have a choice to legal representative of his own choice, and there was no right to appeal, because at that time the court was established for only one level, and the trial was conducted once and for all. And the Supreme Court was established in 1955. According to some documents, in particular the text entitled Cambodia, Building a Law System from Empty Hand. In that particular text, it indicates the right to appeal was reduced to none. And in reality, the Ministry of Justice was the only institution to review the judgment and the accuracy of both legal and factual issues. And the role and power of the judicial body was limited. Until 1992, after the Paris Peace Accord and during the transitional period led by the United Nations Transitional Authority in Cambodia, the judicial system was improved, and that provision regarding the judicial system, criminal law, and criminal procedural code were implemented and enacted over times. And at that time, also courts have been was established at cities and provinces. The Supreme Court was also established, and the rights of the accused was also restored. And there was lacking or shortcoming in the judicial system, the existing judicial system, and we note that such a shortcoming was in place. And in 1993, the National Assembly of Cambodia enacted the law on the criminal procedures, and this law was included or encompassed all the significant provisions of French civil code, in which the roles and responsibility and the power of the investigators, the investigating judges and prosecutors been restored. And in the law itself, the right to appeal was also recognized. And later on, the Constitution was established in 1993. In that Constitution, commitment has been made and that equality of arms has been recognized along with the respect of general norms of human rights. The principle of independent court was in place, and such effort was really supported by international community. And the government was established from elections in the 1993 general elections, although the Khmer Rouge boycotted such election. Later on, higher institutions on law were also established where people could be trained on legal issues, and this session could last up to 4 to 5 years, compared to the previous period where such education was only conducted for a short period of time. Until 1995, the Bar Association of Cambodia was then established. In light of that, the legislative body and the executive body are able to worked together to make new laws, including the laws on the outlawing of the Khmer Rouge of 1994. In 1997, the royal government of Cambodia made requests to the United Nations to establish a court that is in conformity with the international standard to prosecute crimes committed under the Democratic Cambodia. According to these arguments, we can note that the judicial system of Cambodia in the past was shortcoming because it was destroyed by the Democratic Cambodia. Times are needed to make sure that a proper and functional judicial system could be re-established. For example, trainings of lawyers, judges and prosecutors need to be underway to improve the judicial system and legal system in Cambodia.
There is an organization and establishment of the judicial system to be functional, and so far they are still not competent to be a standard. Number two, in relation to the social instability in Cambodia. After the Liberation Day of 7 January 1979, Cambodia was still in the civil war and instability, and the accused still continue to lead the forces opposing the government. The forces of the accused controlled parts of Cambodia, and they used the mountainous areas near the Thai border to be their strongholds to oppose the government. And in particular, at that time, the United Nations still recognized the Democratic Cambodia as the legitimate government, and it had occupied seat at the General Assembly of the United Nations. The accused could act in their full capacity against the government. And if we look at each role of the accused at that time, they were senior leaders. For example, Ieng Sary was the former Minister of Foreign Affairs of the Democratic Cambodia and the legal representative at the United Nations to seek funds to support the Khmer Rouge resistance movement, and later on he controlled areas and he had his own forces at Bailand. Khieu Samphan was another leader of the rebel group, and he was the deputy chief in charge of the foreign affairs within the coalition government of Democratic Cambodia. Ieng Theret was the leader of the delegation for the negotiation on behalf of the coalition government of Democratic Cambodia, and she was appointed as the Secretary General of the Ministry of Foreign Affairs. Nuon Chea was the leader, and he controlled the areas from Sam Lo to Koh Kong, and he gave instructions to those rebellious forces. These combined factors make the accused and their colleagues to control the armed forces in the forest and continue to wage war consequently against the government, despite the existence of the Paris Peace Agreement in October 1991, and even after the establishment of Kingdom of Cambodia in 1993. The forces under the control of the accused still continued to wage war against the government. Cambodia at that time still has certain areas under the control of the accused and not under the control of the Phnom Penh government. And those accused were in that separate areas at the time. The most important issue at that time was to make Cambodia to receive peace, as strived by the government through various solutions and negotiations, which took quite a long time to end the war. And at that time, the Khmer Rouge played an important role in the peace negotiation process. The judicial proceedings during such a war was unlikely to result anything legitimately. As the country did not receive peace or security at the time, the judicial system was not fully independent. For that reason, the investigation or the prosecution of various crimes alleged to be committed by the accused during the decade period could not be carried out. Only in 1996, due to the implementation of the win-win strategy by the royal government of Cambodia, Cambodia gradually received peace, and later on certain Khmer Rouge leaders reintegrated with the government. Despite all that, Nuon Chea and Khieu Samphan continue to lead Nuon Chea and Ieng Sary continue to lead armed forces against the government and did not defect to the government until December 1998. After the reintegration of the Khmer Rouge with the royal government, Cambodia started to enjoy peace and stability. After that, the Khmer Rouge Tribunal was established. Therefore, the acts of the accused to create wars and to wage wars against the Cambodia government for a long period was one of the main factors to prevent the development of the judicial system to be effective. Therefore, the accused shall be responsible for their acts. The President, we need to have a short break so that the DVD disc can be changed.